Very good morning, friends. So, today we'll be talking about the doctrine of separation of powers, right? It's a very important doctrine, especially from your NTA UGC net perspective. So, today we'll be talking about the doctrine. So, I'll be on my phone with the live chat, right? I'll be watching your comments. So, if you have any doubts, please put it across so I can clear it up for you, right? So all these slides are prepared by myself, Cyril Jacob, your educator at Unacademy, right? So let me brief you with an introduction about myself. Myself, Cyril Jacob, I hold a bachelor's in law from Kerala University, a master's in law from Bristol Law School in England. I pursued my diploma in cyber law from Asian School of Cyber Laws, and I'm also a management graduate. That is, I hold an MBA degree with a specialization in HR and marketing. Right, dear friends? So let us start with our class. The concept or doctrine of separation of powers. So, shall we move on to the slides? Before moving on to the slides, I would just like to give an introduction that we'll be considering multiple countries' perspective. Okay, so we'll just give an introduction about what the definition or meaning of the doctrine of separation of powers is. So, separation of powers is an organizational structure. All right, it's an organizational structure in which responsibilities, authorities, and powers are divided. So, there are three factors that should be considered here. One is responsibilities, second is authorities, third is power. All right, they are divided between groups. So there is something called a division of powers between the groups. It exists. There is a division of power that exists between groups rather than being held centrally. Okay, so it is not concentrated, but it is divided. So it is normally associated with political systems, right? Political system meaning governmental establishments, governments, okay, in which the legislative, executive, and judicial powers of government are vested in separate bodies. Now, dear friends, as you will be knowing, there are three branches of the government. First is the executive, second is the legislature, third is the judiciary. So, when we talk about separation of powers, we should understand that every branch of the government is independent in their own functioning and responsibilities and duties. They have to fulfill their responsibilities and duties in an efficient manner, in an effective manner, in the most responsible manner, being vested with powers that are separate. So, when we take an example, okay, let's move on to an illustration. Separation of powers is the tripartite system. Tripartite means it's a three tier. found in the United States and the United Kingdom, in which there are three individual branches of government: the executive branch, the legislative branch, and the judicial branch. Even in India also you will find the system. There is the executive, who is the president of India. Legislature is the parliament, which has the power to make or amend laws, and judiciary is the one which interprets the law or upholds the law in terms of protecting the sovereignty of the country and the constitution of the nation. So some countries have a constitution, some countries do not have a constitution. For example, India has the largest constitution in the world. USA has a democratic constitution as well, but UK does not have a written constitution. You can say it has like unwritten constitution, which forms the basis from, or which derives its laws from codified laws. Codified laws means established or enacted statutes. Statutes are legislations, acts. All right. So separation of power, it exists in UK, US, India, all right, where executive, legislature, and judiciary branches of the government, they are clearly said to exist, all right. However, we should delve into a deeper meaning in order to assess what the doctrine of separation of power, or SOP, stands for. Okay. Dear friends, if you have any doubts, please post it in the comment box so I can see it, because I'm logged on to YouTube as well. So you can post any comments if you have. Right? Moving on. Now, this concept is very important, so please note. The doctrine emphasizes on the mutual exclusivity of the three organs of the government. Mutual exclusivity means they are independent branches. The tree is called government, but that same tree has three branches. Okay, executive, legislature, and judiciary. So the whole concept, or the underlying idea, is that each organ should exercise only one type of function, right? Only one type of function. So what is the logical explanation? What is the rationale of the doctrine? Just imagine, dear friends, in the governmental system, if all the powers are vested only with one particular person, like the chief minister or the prime minister, he has to do everything. He has to be the judiciary. Excuse me. He has to be the judiciary, he has to be the executive, he has to be the legislature. There will be some kind of chaos. There will be some kind of disorder. Smooth functioning cannot be guaranteed absolutely. So the importance that separation of power tries to emphasize on is that there should be mutual exclusivity between the three organs of the government, namely executive, legislature, and judiciary. Hence, if all the power is concentrated or is vested in one same organ, what happens? There would be a kind of danger of state absolutism. That is, everything is vested in one organ. That's the contributes to something called state absolutism. Now, olden days, they used to have one proverb. This particular proverb was given by one Mr. John, right? John. Unfortunately, his surname is not coming to my mind at the moment. But one Mr. John, he was from UK. He was a British jurist. So he gave this particular comment. Okay. So power corrupts, and absolute power corrupts absolutely. Right? Power corrupts, and absolute power corrupts absolutely. If you vest everything into the hands of one man, it will lead to something called as a dictatorship, authoritarianism. So the doctrine of separation of powers was mainly brought into action to control the forces of dictatorship, tyranny, and authoritarianism. Hope you are following. Once again, I'll repeat. This concept of a doctrine of separation of powers very closely observes the old English proverb, power corrupts and absolute power corrupts absolutely. Many of you have heard about it. I'm reiterating it, right? The reason is we have to control the forces of authoritarianism and dictatorship. Moving on, dear friends. Now let us take our wonderful nation, India. In India, the doctrine of separation of powers has not been given a constitutional status. So, when the constitution does not guarantee a particular status or too much mention pertaining to doctrine of powers, doctrine of separation of powers, then we have to start interpreting the constitution from an alternate angle or from an alternate perspective. All right. So, when we have to consider the constitution and the relation of separation of powers that has been enlisted in constitution, we have to look at one particular article, that is article 50. Okay, so apart from the DPSP, which is the directive principles of state policy laid down in article 50, which provides that judiciary should be independent from the executive, and the constitutional scheme does not embody any formal kind of division of power. So there is no formal kind of separation. However, it is to be understood, it is to be implied that exists the doctrine of separation of powers exists clearly in our constitution. We have all the branches of the government mentioned in our constitution. We have the executive, we have the legislature, and we have the judiciary. Right? Article 53 provides for executive powers are vested in the hands of the president. Who's the executive? What is his law? He has to execute laws. Execution of laws means when an legislation has to be passed, you need the president's consent, you need the president's permission, you need the president's assent. A bill does not turn into a legislation or a statute or an act overnight. First, a proposal is made, it is submitted to the parliament, right, by the members, either unanimously or as a private member bill. Then this particular idea will be initiated to be made into a legislation. But it has to undergo 3 readings and then it comes to the president's table for his permission to grant it to be a legislation. So he has the powers. He puts a signature on in the gazette, right, for executing the laws. For a law to be totally implemented, you need the president signature and the seal of his hand. When it comes to state laws, the governor plays a big role with execution powers. pertaining to state laws. So Article 53 provides that the executive powers are vested with the president. Article 154 provides that governor is vested with execution powers. And Article 74 provides that both the governor and the president, both of them exercise power with the help of their advisory board or the council of ministers and the state as the case may deem fit. So the president and the governor, they are both executive in their own rights, exercise ordinance making, that is law making power they have under the constitution, that is the legislative function. So when the executive, he is a separate organ of the government. So when he also has law making, he is intervening into legislative function. Though they are separate, okay, it has to be understood that he also performs legislative functions, that is the ordinance making power. He is vested with the ordinance making power pertaining to state or central legislations. Right? Hope it's clear. Shall we move on to the next slide? Now, the Union Council of Ministers is responsible to the Lok Sabha as per Article 75. So the House has powers to initiate impeachment proceedings against the President. So the President of India, he can be impeached under Article 61, and also the judges of the Supreme Court, but it is not a simple procedure. A lot of substantial facts need to be proved, then only it can be properly initiated. So the judicial function is too substantial pertaining to certain aspects. So how does the judiciary function? It can consider the question of breach or the question of law that is breached, or in terms of any parliamentary privilege, and it has the power to punish under contempt, either contempt of court or violation of laws. Mainly it has to safeguard our constitution, to protect the fundamental rights of the citizens of the country. Right, dear friends? Moving on. The executive in India is authorized, right? He has a authority to legislate in the name of delegated legislation. He's performing the legislative function. So he can legislate in the name of delegated legislation. The reason is because he is authorized. He has the authority. In the name of administrative adjudication of the right of individual citizen, the administrative agencies that include statutory tribunals and domestic tribunals have been constitutional and perform judicial function. So when it comes to administrating certain aspects for individual citizens and their rights, the agencies pertaining to administration agencies that may constitute of or consist of tribunals, domestic tribunals, or any such particular court, they have constitutional and perform judicial function. All right. Now let us move on to some important case laws, because it is really important to consider the prime factor that from the case laws one can receive a lot of principles that we derive. Okay, apart from reading between the lines, you need to interpret the case laws. So let us do that. Pertaining to a judicial opinion of separation of powers, there is the landmark case reported in the All India Reporter, right? That is the case of Ram Javaya Kapoor, Please note down. Ram Javaya Kapoor versus State of Punjab. Reported in the All India Reporter, in the year 1955, Supreme Court, precisely at page 549. In this case, the Supreme Court held that it's a verbatim, that is word to word judgment. The Constitution has not indeed recognized the doctrine of separation of powers. So, in the words of the Supreme Court itself, the Justice Bench noted that the Constitution has not indeed recognized the doctrine of SOP or separation of powers in its totality or in its concrete form or in its absolute rigidity. However, the functions of the different parts on branches of government have been sufficiently differentiated. So, although the Constitution of India, what we can understand from this is that although the Constitution of India has not recognized the doctrine of SOP in its totality, the functions of the different parts of the branches of government have been sufficiently differentiated. That is the first case. Moving on to the second case. In the landmark case of Keshavananda Bharati versus State of Kerala. Now, this was the case where the structural basis of the constitutional framework was safeguarded. So, the legendary Keshavananda Bharati, he's still alive, and in the year 1973, he played a key role in filing a petition against the state of Kerala, and the matter reached the Supreme Court. And it is reported in the All India Reporter in the years 1973 Supreme Court cases, right? Precisely at page 1461. So, in Keshavananda Bharati versus State of Kerala, the doctrine of separation of powers is spoken like a structural basis of the constitutional framework. And so it was held that it cannot be destroyed by amendment. The basic structure of the Constitution, which enlists the fundamental rights, part 3, cannot be destroyed by amendment. So there is this legendary lawyer advocate whose name was Nanibai Palkiwala. He helped Keshavananda Bharati understand the importance of safeguarding the constitutional framework, the basic structure of the constitutional framework. Right? The supremacy of the constitution. Now, constitution is a supreme law of the land. So, in Keshavananda Bharati versus State of Kerala, the Supreme Court understood the importance of separation of powers. It understood the importance of the basic structure, how it has to be safeguarded. The Supreme Court also observed that no basic structure of the constitutional framework can be destroyed by amendment by the Parliament. Right? Any doubts, dear friends? Please be free to ask. Let us move on to the third case law, and then we'll talk about separation of powers in USA. Like I told you, we have few countries to be considering. So there is this case Bandh Mukti Morcha versus Union of India. All these, dear friends, please note down all these three cases. They are landmark judgments. Landmark judgments are those judgments which are cited in multiple cases, and the principles are applied multiple times, several times. Okay. So, in the case of Bandh Mukti Morcha versus Union of India, reported in the All India Reporter 1984 by the Supreme Court, precisely at page 802, Justice Patak, right? It was Justice Patak who led the judgment, and he stated that the Constitution envisages, that means it enlists, a broad division of the power of the state between the executive, legislature, and judiciary. So, what more do you want? Justice Patak, he clearly observed that the Constitution provides for a division of powers or a separation of powers. However, although it is not clearly stated, he went on to say that although it is not precisely demarcated, that is, it has not been clearly expressed, there is a general acknowledgement of its limit. What is the limit? That there is a division of powers. There is a broad division of powers. So you need to read between the lines. That is what Justice Patak also encouraged in his judgment. The limits can be gathered from the written text of the Constitution. So we have to read the text of the Constitution, the subtext, the clauses, the provisions, to understand that there is a broad division of powers between three branches of the government. Moreover, we have to look into conventions and constitutional practice. Constitutional practice. People who are well versed with the Constitution will be having a lot of opinion about the Constitution. There are people in India who are not lawyers but who are very well versed with the Constitution of India. One example I'll give you, Dr. Subramanian Swamy. He is very well versed with the Constitution. Then there are other people who study the Constitution they do an in-depth and critical analysis. Okay, to bring out or read between the lines. It's like reading your favorite novel, and we both read. Okay, you and me, we read a particular novel, say Paulo Coelho's novel. Now, he has written the legendary book of The Alchemist. Now, how I perceive that book to be is not how you perceive that book to be. Okay? Definitely, we have that entire beautiful concept of the beautiful ending where the boy finds what he was looking for. It was somewhere near him itself. Right? So, but how beautifully he constructed that story. Your perception of reading it is totally different, right? You will perhaps consider further dimensions than mine. So there are constitutional practitioners or big advocates who interpret the Constitution and conventions. What are conventions? They are protocols, they are laws. Okay, from this it can be understood that there is a division of powers or separation of powers in India. Moreover, what is the duty of the judiciary? It is to uphold the law, it is to interpret the law, and to give judgments. Judiciary is nothing but the courts of law. So, hierarchy of courts itself, we have district level, state level, national level. The highest court of appeal in India is the Supreme Court of India, and all these decisions, okay, of how separation of powers is being enlisted, but it is not in its absolute rigidity, or it forms the structural base of the constitutional framework, or whether it should be clearly gathered from the Constitution that it exists. All these decisions, from the first case till the last case of Bandh Mukti Morcha versus Union of India, right? From 1955 till 2019, or from 1950 to 2019, the Constitution it's like it's still alive. The document, wonderful document, governs the nation. It's the supreme law of the land. So there are jurists who believe that it is something like it safeguards and protects the citizen, and it should not be tampered with. The fundamental structure should not be tampered with. So hope you followed. Now let us move on to United States of America. Right? So in USA, the doctrine of separation powers is clearly mentioned in the American constitutional structure. We'll be moving on to how administrative growth and also England, right? Meanwhile, let us understand that the doctrine of separation of powers, it forms the basis or the foundation of American constitutional structure. So these articles, namely 1, 2, and 3, that is the primary articles, it delegates and separates powers and also emphasizes or exemplifies, it's an alternate word for emphasizes, the concept or doctrine of SOP. So when you look at these three articles, you will find the doctrine of SOP clearly expressed. Article 1 provides that there is the legislative power in the Congress. So in USA, the parliament is called Congress. Congress is not a political party. There are two political parties, major political parties in USA, that is the Democratic and the Republic, or the Democratic, the Republican, right? The legislature is called the Congress. Okay, Congress has two houses, namely House of Representatives and the Senate. India borrowed the parliamentary form, like I mentioned in one of my presentations. They borrowed the parliamentary from United Kingdom. Okay, where UK has two houses, House of Lords, House of Commons. India has the upper house and lower house, like the UK, upper chamber, lower chamber. We have the Rajya Sabha, Lok Sabha. So USA, it's a presidential form of government, right? It's a presidential form of government. So the executive power is vested in the hands of president. Right now, the president is Mr. Donald Trump. So he is the executive of the country. And the constitution provides him that right. Article 3, judicial power of the Supreme Court. In USA, there are each state having Supreme Court. I'll just put SC. But however, there is one federal Supreme Court in Washington, D.C. That's the federal Supreme Court of USA. That's the highest highest appeal court in the United States of America. So the Congress, which is the legislature, constantly or continuously probes into, looks into, delves into executive functioning through various committees. So there are various committees that conduct a probe or a investigation into the functioning of the branch of the government, that is mainly the executive. Okay, and it has the power to tax and sanction money for governmental expenses. Legislature, it makes laws, it amends laws. Kindly remember, the Supreme Court in the USA has the power to declare acts passed by the Congress unconstitutional. So when is a legislation declared as unconstitutional? When it is violating the provisions of the American Constitution. So that is the judicial function, right? The justice, the judges, they are appointed by the President of America. But however, there is an approval of the Senate. Senate is the one of the parliamentary houses, right? So, House of Representative is there and Senate exists. These are the two houses of Congress, of the legislature. Right, dear friends? So, the president has the power. Like recently, Donald Trump appointed one of the Supreme Court judges. But however, he should understand that the legislature has the power, the Senate has the power to veto that decision. Veto means prohibit him from appointing that particular Supreme Court judge. Alright? Dear friends, if you have any doubts, please let me know. Okay? I'm on logged on to my phone through watching YouTube, right? And I'm looking if there are any comments. So if you have any doubts, please post, as this is a live session. So what we can understand here is that the Supreme Court of USA, the judges are appointed by the president, but however they have to get the Senate's, he has to get the Senate's approval. They can prohibit appointing a judge if they believe he is not the right candidate. The Supreme Court, it upholds the Constitution and it has the power to declare any acts that are passed by the Congress. So when you understand this, they have a judiciary has a lot of function and legislature has accountability, right? So I will explain that. But moving on, administrative growth and SOP, that is, what is the relationship between administrative growth and separation of powers? If a country has to grow in an administrative manner, usually the doctrine of SOP and administrative growth, they are incompatible, as modern administration processes enlist mingling of various types of function. So there is some kind of relationship that should be exchanged between the three branches of the government. So there is the executive, there is the legislature, there is the judiciary. Say judiciary, we have the Supreme Court. Legislature, it is the Congress or the Parliament. And executive, we have the President. Okay. Now what the executive does is that he is involved with execution of laws. Legislature is involved with making laws or amending laws. Judiciary is involved with the interpreting the question of law and upholding the law. So now exists a kind of accountable relationship. there is a kind of accountability involved. The executive, he is accountable to the legislature. Legislature is accountable to the judiciary. And ultimately, judiciary is accountable to the citizens of the country. The judiciary cannot interpret laws or uphold any law that is unconstitutional. They have a supreme power. There is a supreme power vested with the Supreme Court of a country, that they can declare any law that is violating the provisions of the Constitution as unconstitutional or invalid. So legislature, it has to make laws, but those laws can be struck down as invalid by the judiciary. But when it comes to administration level growth, if you want to grow, if a country wants to grow pertaining to administrative policies, the doctrine of separation of powers has to be diluted. Why it has to be diluted is because separation of powers, the concept or doctrine, provides that there should be a division of powers. But however, if you want to accommodate an administrative process in your country's system, you need to dilute it or dissolve it. You need to bring it down. You should need to lessen the impact. Right? Any doubts, dear friends? Kindly let me know if you have any doubts, right? So, with this flow chart or this small diagram, hope you have followed the importance of executive, legislature, and judiciary. Yes, sometimes they have to intervene. Like executive, he has the ordinance making ability. Same thing with USA also. Ordinance making power. Right? Moving on, dear friends. If you have any doubts, please let me know. All right. There's no doubts. I'm moving on. We have SOP in England and SOP in France, right? So SOP in England, very important. Please take notes. So there is one person called Maitland. His work is very much appreciated pertaining to the doctrine of SOP and even other concepts. So Maitland, he traces back the doctrine of separation of powers to the reign of King Edward the First. So there is the legendary King Edward the First, who ruled from 1239 to 1307. That is, since the 12th century, this SOP has been present in the world. Okay, so Maitland made a vital observation that all the three elements, that is the executive, okay, King's Council is the executive council, okay, King is the executive, Parliament is the legislature, and courts of law is the judicial system, judiciary. So the three branches of government, these three can be traced since the reign of King Edward. That is what Maitland found in his observations. Right? Then there is a committee called the Donoughmore Committee. This made certain vital conclusions. These are very important, so please, you should follow. So In the British Constitution, basically they have an unwritten constitution. They do not have a written constitution. There is no such thing as absolute separation of powers. That means there is a dilution involved. And the UK government, they recognizes that. So with regard to constitutions like France and USA, okay, there have been attempts to keep the three branches separately. Okay, executive is separate, legislature is separate, and judiciary on the other hand is a separate organ. Attempts have been made to keep it separate. However, when such attempts are being made, one should know that it can turn out to be a failed attempt. It can be turning out to be an unsuccessful attempt. Because without, there is no country that can absolutely claim that separation of power exists in its totality or rigidity. Because executive, he performs what function? He's performing the legislative function when he's giving his assent for a bill to be made into a statute. Right? For a bill to be made to a statute, he's giving his assent. Then he's intervening into the legislative functioning. He's performing the legislative function. If I'm just giving an example, a random imagination, I wanted to imagine that if the legislature themselves approve without the consent of the president, then it can be said to be truly independent. Okay, if legislature themselves are making amending laws without anybody's consent, then they are truly independent. But that's not the case. They need to have the president's assent for making the laws, because he helps in execution of the laws. He gives the signature. Under his sign and seal, a bill becomes or ordinance become a legislation. Remember what I told you in the first few slides. Ordinance making power lies with the executive, that is the governor and the president. So friends, hope you are following. If you have any doubts, please go ahead and ask me. So all the attempts to make the three branches, to keep the organs of the government rigidly apart, have been made. However, they have proved to be unsuccessful. This is what I was mentioning. So there is no such thing as absolute or concrete SOP. No absolute SOP exists. It is all a dilution. Because remember the previous slide, dear friend, when I told you that for administrative growth and SOP as such, they are little bit incompatible. What is incompatible? It's failing to get along completely, properly, well. There is a kind of a combination. This combination, when it's not able to merge well, when there is some kind of a crack, then system cannot function smoothly. There cannot be smooth functioning. So the doctrine of separation of powers has to be little bit, it has to be, there's another alternate word which I want to use, watered down. It has to be slightly taken a bit lesser. The impact should be loosened. Then it can accommodate the administrative process, because at the administrative level, it is necessary for mingling or merging of various type of functions. That is the executive function, legislative function, and the judicial function. There has to be some kind of an appreciation and intervening. Right, dear friends? Hope you are following. Now let us take into account the doctrine of separation of powers in France. Now briefly, let me explain to you how the doctrine of separation of powers came into being. There is this legendary person called Baron de Montesquieu. So Montesquieu, he came with a particular book. This is the English translation on the spirit of laws. The French version is called Esprit de la Louis. Okay, authority. This is considered as a foremost authority on the doctrine of separation of powers. So Montesquieu, in the year 1748, he published a book called Esprit de la Louis, or On the Spirit of Laws, which is the English translation. He was a French philosopher. He was a genius because people till today, till date, various governments of the world, whether it is the United States of America, whether it's the United Kingdom, whether it's the France, whether it's the Indian government, you take any continent in the world, there will be people who have followed the work of Baron de Montesquieu. Montesquieu made certain arguments. Okay, he was very much in favor of separation of powers. He also believed that power corrupts absolute power corrupts absolutely. And he had something in his mind when he wrote this book on the spirit of laws. So Montesquieu argued that in order to prevent corruption, the government must be classified into three branches. Okay. So his idea of separation of powers have become the blueprint for many functioning governments today. His idea of or doctrine or his concept, for an idea it starts with a concept in his mind. It was a conceptual processing. Conceptual processing led to this book in 1748, that's the Spirit of Laws. It became the blueprint, that is the book to follow for many functioning governments today. So his work is carefully looked into. Right? Now, dear friends, this doctrine of separation of powers in France also achieved its share of glory. So the French Constitution was adopted on 4th October 1958 and is known as the Constitution of the Fifth Republic. The French Constitution is called the Constitution of the Fourth Republic, and it replaced the Constitution of the Fourth Republic. So the present Constitution is a replacement. So there have been, because advancements are in place, the society is evolving. For example, today you do not find people wearing clothes what they used to wear in the Iron Age or the Medieval Age. The dressing sense have changed, the eating habits have changed, the thinking processing have changed. We evolve. So when humanity is evolving, why should not law evolve? But there are some legendary documents that stands the test of time. One such document is the work of Baron de Montesquieu. It has stood the test of time. Since the 16th century, he has been advocating for something like this, and when he published a book in 1748, people started taking note, and since 1748 till 2019, over 3 centuries, okay, almost 3 centuries, people know that there is Montesquieu and his work has been appreciated. So the type of government in France is the semi-presidential unitary government. Semi-presidential unitary government. Today the president of France is Emmanuel Macron. Okay. So the constitution provides for separation of powers and proclaims France's attachment to the rights of man. They have a declaration called the Rights of Man. This Rights of Man has a series of articles. It leads to protecting the fundamental rights of humanity such as equality, okay, basically works for upliftment of citizens of the nation. Okay, but this rights of man has a universal appeal. So constitution provides for SOP in France. Okay, it encourages that there exists, it appreciates that, or it acknowledges that there is separation of powers, and it can be found in the attachment to the rights of man and principles of national sovereignty as defined by the Declaration of 1789. Okay, so the three branches clearly exist. First branch, executive. Like I mentioned through the chart, executive is the president who enforces the laws. In France, the legislature, that is the parliament, has two houses, namely the National Assembly and Senate, and they have a 9 month session. Okay, 3 months of break and 9 months in action. Then, if we follow the hierarchical court system in France, okay, there are inferior courts, appellate courts, court of cassation, and the Supreme Court. You can say cassation, not cessation. Yeah. So they have various chambers like the civil chamber, civil law chamber, criminal law chamber, right? Commercial law chamber, and it goes on. The Supreme Court of France is located in Paris. Some people say Paris, some people say Paris. I would like to stick to the latter. It's the capital of France. So, just rewinding what we learned today, we talked about doctrine of separation of powers. From different countries' perspective, we talk about how it is defined and what the meaning is. We talk about the tripartite system found in USA, UK, and especially India. We talked about the logical rationale behind the doctrine, how power corrupts and absolute power corrupts absolutely, right? Then we talked about how important it is pertaining to India, with that Constitution of India as such has not given a constitutional status to this doctrine of separation of powers. But if we read between the line, and we also handled various case laws like Ram Javaya Kapoor, Keshavananda Bharati, and Bandh Mukti Morcha case laws, which were reported in the Supreme Court from 1955 to 1984. Until today, this stands true that lawyers, philosophers, constitutional practitioners, and judicial decisions forms the basis for separation of powers, right? Then we studied about separation of powers in USA, how it functions how it lays down the foundation in three articles, namely 1, 2, and 3. Then we went on to administrative growth and separation of powers. Also, we talked about how SOP functions in England since the reign of King Edward I. It can be traced. Then we talked about the great Baron de Montesquieu and his work, separation of powers, and how it contributed to France. So, dear friends, I would like to just tell me, please follow my channel. Okay, follow me on Unacademy. You can use my referral code. I'm just going to give you that code. You get a 10% off. Okay, use my referral code Cyril Thomas Jacob. Yeah, that's my name, full name. So CYRILTHOMASJACOB, Cyril Thomas Jacob. Subscribe to the channel and you'll get a 10% off. The benefits of subscribing to Plus platform is that you have weekly quizzes. You can take a series of tests in the mega quiz. at the end of each course. Then you can have special doubt clearing sessions. There are doubt clearing sessions. You can have live chats. My doubt clearing sessions are 2 hours, right? Normally my classes are in the evening. So there is weekly quiz, mega quiz, doubt clearing session. Through all this, you can track your learning path